Thank you for visiting the Combs Waterkotte YouTube channel. We are a leading criminal defense law firm in Illinois and Missouri, with over 600 perfect reviews and a long history of client satisfaction, criminal case dismissals, charge reductions, and victories. Our firm has created these audio articles to help protect your freedom, reputation, and rights. If we are hired for your case, we will not give up until you receive fair justice. Carjacking Lawyer, Chicago, Illinois. Being charged with carjacking in Chicago, Illinois is a serious and overwhelming situation. Carjacking in Cook County is prosecuted as a felony, and a conviction can lead to significant prison time, steep fines, and long-term consequences for your record and future. In a city like Chicago, where prosecutors aggressively pursue violent crime charges, having a skilled defense lawyer on your side is critical. If you're facing a carjacking charge in Chicago, you don't have to handle it alone. The veteran criminal defense attorneys at Combs Waterkotte have over 8 decades of combined experience defending clients against serious felony charges. We understand how high the stakes are, and we're here to help you build a strong defense and protect your future. Call 312-500-HELP today to get started. Carjacking Lawyer in Chicago, Illinois, serving all of Cook County. Carjacking charges in Chicago, Illinois, and throughout Cook County are aggressively prosecuted, often carrying severe felony penalties and long prison sentences. When you're facing accusations this serious, you need a defense team that understands how to challenge the prosecution's case and protect your rights at every stage of the process. At Combs Waterkotte, we know that every case has 2 sides. Allegations of carjacking in Chicago can arise from mistaken identity, unreliable witness testimony, or incomplete investigations. That's why we take a thorough, strategic approach to every case, digging into the details, examining the evidence, and identifying weaknesses in the prosecution's argument. Our team brings more than 60 years of combined criminal defense experience to the table, and we use that knowledge to pursue the best possible outcome for our clients. Whether that means negotiating to reduce or dismiss your charges or fighting for you at trial, we're prepared to stand by your side every step of the way. If you're ready to fight back against your Chicago carjacking charges and protect your future, contact Combs Waterkotte today at 312-500-HELP or reach out to us online for a free confidential consultation. What is carjacking in Chicago, Illinois? In Chicago and Cook County, carjacking, officially called vehicular hijacking under Illinois law, falls under the robbery section of the Illinois Criminal Code. 720 ILCS 5/18-3 defines vehicular hijacking as knowingly taking a motor vehicle from a person, or in the presence of a person, by using force or the threat of force. That's all there is to the statute. It's short and to the point. There is, however, a more severe form of vehicular hijacking on the books in Illinois: aggravated vehicular hijacking. This offense is a bit more detailed. It covers situations in which someone steals a motor vehicle from a protected or vulnerable individual, using a dangerous weapon or firearm. Unsurprisingly, aggravated vehicular hijacking carries more severe penalties than the base-level vehicular hijacking offense in Chicago. What are the penalties for carjacking in Chicago, Illinois? Under 720 ILCS 5/18-3, vehicular hijacking is always charged as a Class 1 felony, one of the most serious felony charges under Illinois law. A Class 1 felony conviction comes with a few possible penalties, including a prison sentence between 4 and 15 years, a possible extended prison term of 15 to 30 years, a possible fine up to $25,000, a mandatory 2-year period of supervision upon release. If prosecutors are unable to prove the force or threat of force component of a vehicular hijacking charge, they may settle for a possession of a stolen vehicle charge. This offense, which is much easier for prosecutors to prove in court, is a Class II felony, with penalties including a prison sentence between 3 and 7 years, a possible extended prison sentence between 7 and 14 years, a possible fine up to $25,000, a mandatory 2-year period of supervision upon release. Aggravated vehicular hijacking carries the most serious penalties possible for a carjacking offense in Chicago, Illinois. 720 ILCS 5/18-4 mentions that the offense is charged as a Class X felony, with penalties including a prison sentence between 6 and 30 years, a possible extended prison sentence between 30 and 60 years, ineligibility for probation, a fine up to $25,000, a mandatory 3-year period of supervision upon release. Because aggravated vehicular hijacking involves the use of a weapon by definition, an extended term for a conviction is very likely, potentially resulting in decades behind bars. Prosecutors may feel inclined to stack an aggravated unlawful use of weapons AUUW charge, meaning additional years added to the sentence that are likely to run consecutively. What to do if you're arrested for carjacking in Chicago, Illinois? While a vehicular hijacking charge is a very serious allegation in Cook County, there are still steps you can take immediately after your arrest to protect your rights and bolster your criminal defense. The criminal defense lawyers at Combs Waterkotte recommend doing the following if you're arrested for carjacking in Chicago. Exercise your right to remain silent. If you are arrested for carjacking in Chicago, exercise your right to remain silent immediately. Law enforcement may try to question you, and anything you say can be used against you later. Politely refuse to answer questions and request an attorney. Even seemingly harmless statements can be misinterpreted or used to build a case against you. Request a criminal defense attorney immediately. Ask for a lawyer as soon as possible after your arrest. Carjacking charges in Illinois carry severe penalties, especially if a firearm is involved. An experienced defense attorney can begin protecting your rights right away, advise you on what to say or not say, and start building a defense strategy tailored to your case and your specific allegations. Avoid resisting arrest or escalating the situation. Do not resist arrest, argue with officers, or attempt to flee. This can lead to additional charges and make your situation significantly worse. Stay calm, comply with basic instructions, and avoid any behavior that could be perceived as threatening. Your focus should be on protecting your legal rights, not escalating the encounter in a way that harms your defense. Do not discuss your case with anyone else. Avoid talking about your case with friends, family, or anyone other than your attorney. Phone calls from jail are often recorded, and messages or social media posts can be used as evidence against you. Even casual conversations can be taken out of context. Keep all the details of your case private to avoid unintentionally damaging your defense. Act quickly to preserve surveillance or vehicle evidence. Carjacking cases in Chicago often rely on surveillance footage, license plate readers, or forensic evidence from the vehicle in question. This evidence can disappear quickly if not preserved. An attorney can move fast to secure video, dispatch records, or GPS data that may support your defense or contradict the prosecution's timeline of events. Prepare for the bond hearing and next steps. After your arrest, you will likely face a bond hearing where conditions of your release are determined. Your attorney can argue for your release or reduced restrictions. Be prepared to provide relevant background information, such as employment history or relevant community ties. Early preparation can improve your chances of a more favorable outcome. Criminal defense strategies against carjacking charges in Chicago, Illinois. Despite the seriousness of a vehicular hijacking charge in Chicago, a good lawyer can still provide a solid defense designed to achieve a favorable outcome. Here are some of the criminal defense strategies that the expert attorneys at Combs Waterkotte have found to be helpful in defending clients against carjacking charges. Challenging identification and eyewitness accuracy. Carjacking cases often rely on eyewitness identification, which can be unreliable, especially in fast-moving, high-stress situations. Lighting, distance, and fear are all factors that can all impact a witness's memory. A defense attorney may challenge lineups, photo arrays, or in-court identifications to expose inconsistencies and raise reasonable doubt about whether the defendant was actually the person involved in the carjacking. Fourth Amendment violations. If police obtained evidence through an unlawful stop, search, or arrest, that evidence may be suppressed. This can include vehicle searches, GPS tracking, or seized property. If key evidence like a weapon or stolen vehicle is excluded, it can significantly weaken the prosecution's case and, in some situations, lead to reduced charges or a complete dismissal. Miranda rights violations. If law enforcement failed to advise you of your Miranda rights before an arrest or interrogation, your statements may be inadmissible. This is especially important in carjacking cases where prosecutors rely on confessions or incriminating statements. Challenging how and when statements were obtained can limit the evidence available to the state. Lack of intent. Vehicular hijacking requires proof that the defendant knowingly took a vehicle by force or threat of force. If the defense can show that the incident was nonviolent or that it was a misunderstanding, and there was no force involved, the charges may be reduced to a lesser offense or dropped entirely due to a lack of intent. Alibi. An alibi defense demonstrates that the defendant was somewhere else when the alleged carjacking occurred. This can be supported by surveillance footage, phone location data, receipts, or witness testimony. A credible alibi can completely negate the prosecution's case by proving it was impossible for the defendant to have committed the hijacking. Coercion or duress. If the defendant was forced to participate in a carjacking under threat of immediate harm, this may serve as a valid defense. Carjacking cases sometimes involve multiple individuals where one person coerces or threatens another to take part under duress. Demonstrating a lack of free will or meaningful choice can be critical in reducing or avoiding criminal liability. Challenging use of force element. Because force or the threat of force is required for a vehicular hijacking charge, disputing this element can be a powerful defense. If the incident involved no actual force, intimidation, or threat, the charge may not meet the legal definition of carjacking and could instead be treated as a lesser offense, like possession of a stolen vehicle. Combs Waterkotte is a leading criminal defense law firm serving the entire states of Illinois and Missouri. We have offices in St. Louis, Chicago, Kansas City, Clayton, Branson, and Belleville. We look forward to helping you with your criminal defense attorney needs.